thank you very much for coming. We appreciate everyone being here. SkyDeck and BPEP, the Berkeley Postdoc Entrepreneur Program, are very glad that we can, even in a day where we never know when it's going to start raining, that we still can get this this crowd here. Without further ado, I would like to introduce you to Brian, who will be discussing with us alternatives or ways in which people from other countries who want to develop their enterprises in the United States can get a hold of it. Brian, please be very welcome at SkyDeck.
Thank you.
And here you go.
Oh,
you have
yes.
another one. Okay.
It's got me set up. Thank you very much. So what I'm going to do today, this is really an interactive presentation, is the idea to give you information about the U.S. immigration system that hopefully will be helpful if you're considering your next move, whether it's joining a private employer or starting your own company, whatever it is that you intend to do here in the U.S. And as I talk about these things, please feel free to just raise your hand and ask a question. That's what I'm here for. It's very great, actually, I think, that Berkeley presents this program, because I've given this particular presentation at different offices of my firm, and this is the first time that it's happened in this environment, which I think is exactly a great chance in your career to be thinking about these ideas. So that's what I'm here to talk about. The first slide here is just your normal law firm disclosure, but there's an important reason why this is here today. The slide is basically telling you that what you're hearing today is not legal advice. I'm not trying to tell you exactly what you should do in your personal situation. But at the same time, I'm going to give you information that I hope is deeper and more meaningful than just sort of what you might find on a website if you try to figure this out on your own. So I hope to give clarity, but if you have follow-up questions, reach out and work with an attorney, whether it's me or someone else, to get really drill down into your specific situation. I'm part of a law firm called K&L Gates. It's the Gates in the name is actually Bill Gates's father. That's the namesake of the firm. It's all over the world. We've got about 1,800, 1,900 attorneys worldwide. The map here shows you where our offices are located and some of the distinctions of our law firm. I head up our U.S. immigration practice. So my job is to take care of the immigration that occurs throughout the world, basically, coming here to the U.S. That's my picture in case you don't know which one is me. All right, so today, the immigration challenges that you probably all are facing or could potentially face, among them is the fact that we have a really pretty bad immigration system. The immigration system that we have was created in the 1950s, and it had no idea of contemplating foreign entrepreneurs and the technology revolution. It just wasn't designed for that. There's actually no visa category specifically for an entrepreneur, which seems like a very strange omission. And the other problem you have, not only are there not ideal immigration categories for what we might want, there are extremely harsh consequences if you misuse a particular visa type. For example, if you're on a student visa, how far can you go before you violated the law? And you probably all know if you violate your student status, that's it. It's reported to the government. You lose your F1. You have to go back. It's a really harsh environment. So there are all sorts of increased consequences for having the wrong visa type. There's also increased scrutiny by the immigration authorities. And that's a growing problem as intelligence and technology just gets better and better and better. It used to be maybe 20 years ago when I started practicing, there weren't computer records of everything you've ever done in your life. And now that's more and more prevalent. When a person's entering the country, sometimes records come up from 40 or 50 years ago as we improve intelligence. There's also, we're in the middle of this changing attitude towards immigration. It's like a pendulum. It's been happening this way ever since, really, since the late 1800s. It's been going back and forth between, do we welcome immigrants, do we not welcome immigrants? We're currently somewhere on the wrong side of that swing, so that makes it a little bit more challenging. And of course, there's always the potential for new immigration laws. Maybe it will happen, maybe it won't. A new Congress is coming in a little less than 2 months, and maybe that will change somehow the balance of power. So that's sort of the biggest of the big pictures. So where do we fit within that? What are the paths forward? And the good news is there are plenty of paths forward. The first step is to understand kind of what those paths look like. It's sort of like if you've ever been to a fair or a carnival, you know, the little games where you throw a ball at a target, and if you hit the target, you get a prize. Well, often in immigration law, the problem is nobody knows where the target is. So you're basically throwing a ball and you have no idea if it's the right direction or not. What I'm hoping to do today is to give you a sense of what those targets look like. So it's important as you think forward about what is it you'd like to accomplish, where would you like to go, it's important to understand how the existing options or targets align with your goals. If you decide, for example, that no matter what happens, I'm going to start my own company, I'll own 100% of the stock, and I'm going to start working before I get my work authorization, that's not necessarily aligned with the immigration goals. So it's important to get in touch with that. It's also important to have both a short-term plan and a long-term plan in immigration, because what's so critical to understand is sometimes the quickest way to where you want to go may involve leaving the country and coming back as opposed to just simply staying. We'll talk more about that. Be aware of the increased scrutiny. So something your friend may have done 10 years ago or 5 years ago may not necessarily work. There's more and more scrutiny all the time at the border and within the system. And lastly, it's important to try to stay informed with good information. How do you get good information about immigration? It's similar to trying to figure out a medical condition online. You know, you get all sorts of conflicting information out there. Try to avoid the stories of what your friends told you or those types of anecdotal things, and go to more reliable sources. Law firms are a good source of information usually because they're not concerned about the anecdotes, they're concerned about the realities. Also, the government websites are pretty good, actually. USCIS and the State Department have some fairly decent materials online that give you the basics and sometimes answer some pretty in-depth questions. So this presentation will start with sort of the roadmap, if you will, starts with an F1 status. How many of you currently have F1 out of curiosity? Okay, relatively few. How many have J1? Okay, so I'm going to talk about J1 right after I talk about the F1 situation, since that's actually what applies here. It's similar in the sense that this is your starting deck. Yes? H-1B? You have a cap exempt H-1B with the university? Okay, we'll talk about that too. So you're in a slightly different situation. I would consider you somewhat one step further down the road than where we'll start from. So we'll start with just a generic student. Typically, that's an F1 student visa. And the F1 is so there's several student visa programs. Obviously, there's F1 and J1. The main difference, as I told someone earlier today, is F1 is designed to have a student come into the United States and really study, get a degree, get some practical work experience. And then if they want to stay, it's relatively well designed for that. The J1 is an exchange program. It's actually the name of the visa is the exchange visitor. The idea is you come and then you go back. So it's not as well designed to give a clear path to stay here. There is a way, but it's not quite as easy. So with the F1, you basically have 3 different types of work authorization that are the beginning of the bridge into a work visa. The first type of work authorization is while you're enrolled full-time in school, you can get curricular practical training, which is basically getting college-level credit for working off campus. It can be full-time or part-time. After graduation, there's a 1-year work authorization, and you can actually use that work authorization to start your own business. So someone whose ultimate goal is to stay here and start a company, who's an F1 student, the good news is you can actually legally do that with your work authorization after graduation. If you have a degree in a STEM field, which I would imagine, do all of you are working on STEM degrees? Okay. Then you have the option of a 2-year extension beyond that first year, as long as you work for an employer that participates in the E-Verify program. Most employers that hire STEM graduates are now part of E-Verify for this very reason. So the J1, I don't have a slide for that, but I'll tell you about that since you obviously know most of it. But the idea with the J1 visitor program is you don't get an automatic work authorization attached to it. There are options to be a J1 intern, obviously, that allow you to study while you're in J1 status. But it doesn't really have anything this concrete in terms of a work authorization card after you get your degree. So the transition for a J1 is often one of 2 paths, and there really are 3, which your example earlier is sort of a variation of the second path. The first path, let's say you have a master's degree and you decide you want to stay and get a PhD and then perhaps start your own business. It's often a good idea to think about moving to an F1 for that next degree because of the benefits that you see here, because of the OPT, the work authorization that you get following that degree. So some people that start out as J1 that have the intent to stay will transition over to F1, and that's something that can be done. It's a potential path. The second potential path that you often see is applying for a work visa like your H-1B or the other ones that we'll talk about today, and filing a change of status. So you file a petition with the Immigration Service, or your employer does, and if it's approved, you just stay where you are, and suddenly instead of being a J1, you're an H-1B or some other status. The problem that many J1s have is, of course, the 2-year home residency requirement. I don't want to ask you for show of hands on that, but probably some of you are subject to the 2-year return home requirement. Okay, yeah, and so there's limited ways to get that requirement waived. There are some ways, but that's a challenge if you have a J1 with that 2-year restriction. Part of the problem that I see, just from doing this for over 20 years, is the government often isn't even clear whether you're subject to the 2-year requirement. You have, your visa sometimes has a notation whether you're subject or not subject, but you can have a DS form from the State Department that has a different, or maybe nothing is checked. So there can be a little bit of ambiguity sometimes for some people as to whether that 2-year rule applies. I would say, as a general observation, if it does apply, the hardest one to waive, you can apply for certain waivers, is if the U.S. government paid the cost of your education. If this, because the State Department has programs like the Fulbright Scholar Program and others. If they paid for you to come here, they're very unlikely to waive that. You're asking the same agency that gave you the money to waive that condition. It can be done, it's just the most challenging. The least challenging is if the reason for the 2-year waiver is the skills list. Does this make this familiar to some of you? So if the reason you have the 2-year waiver is something called the skills list, what that means is the US government has a list of skills that they believe are crucial for different countries in the world. Maybe in China, they say, well, it's important to have people that have these certain types of degrees. So instead of granting that, letting them stay here and work, we want them to go back home to apply those skills in the home country. Those are very outdated skills. Yes?
So is it because of other countries and their like list of skills, or is it US
It's
deciding
the
on
US's imagination about which skills matter. So
each
it's,
country?
it's all, exactly, and so it may be something they thought about from the 1970s, right? So they think, oh, it's important to have, you know, people with software engineering degrees in China, and China's like, yeah, we've got that covered, thank you. You know,
So it's not
so-
any sort of bilateral treaties or something saying don't do any brain drain or something like that?
No, it's literally the list that our government developed to administer this program. So they'll look and see, they'll look at your country, they'll look at the skill, and they'll check the box. So in order to get the waiver, in those cases, you have to get a no objection letter from your home country. And we've seen those turned around sometimes in a day. You know, the country's like, yeah, we don't care. This is not important. So those are among the easiest of the 2-year bars to waive for that reason, if it's the skills list. The most difficult, again, are if the government paid for it. So that's kind of the general nutshell of the J1, yes?
Do you have any negative consequences of having the waiver?
If you have the waiver, are there negative consequences? There could be. So one of the reasons for the waiver is that you have a fear of returning to your home country. So you make a claim that, listen, I can't go back, I'll be persecuted, I'll be harmed physically if I go back to my home country. Maybe I'm on the wrong side of politics, or maybe there's some other fear of harm like that. So if you get a waiver on that basis, and then you get another visa subsequently, let's say you get an H-1B, and then you travel to your home country, when you're coming back in, they'll say, I thought you said it wasn't safe. And then that can, sometimes, not very often, that can open an inquiry as to whether there was fraud or misrepresentation on the claim. Yes?
What if your home country paid for your education, or like you have funding from Canada, for example?
Right. So that's similar to the first situation where, so if the US government has to grant the waiver ultimately. So if the US government gave you the money, they're the least likely to grant the waiver. Lower down the rung is if your home country has to give the no objection letter and they paid for your education. So let's, using Canada as an example, let's say they have a program to get more people educated in a particular field of study, and they gave money to someone for that purpose. They'd be fairly unlikely to grant the no objection letter if they felt like that destroyed the purpose of the program. So it's really a somewhat of a case-by-case situation, but I'd say generally speaking it can be pretty hard. The more money involved, the harder it is. But that if you one interesting thing about the 2-year residency requirement is it's written in a very odd way. It prevents 3 things. If you ever look at the rule, you cannot change status to H or L, and you can't get a green card. Well, the green card's a big deal, but there's a lot of other different visas besides H's or L's. So what you sometimes see people do is they think, oh, let's just apply for a different type of visa. So we can skirt past the 2-year requirement. So for a Canadian, in your example, let's just do a TN, which is not covered by the 2-year rule. Well, that works perfectly fine, except that when you're ready to eventually get that green card, you've still got the 2-year rule. So now you've got to disrupt what could be a very long period in the United States to go back and get that, either get the waiver or go back for the 2 years. Yes?
If somebody's working in an NSF, NIH project, does that also cause an issue? Is it considered as government funded or?
What type of project? I didn't quite catch.
So this is National Science Foundation.
Oh.
Grant.
Yes, that's more like the first. So if the funding came from the U.S. government in some form or fashion, that's harder to get waived, just generally. We've seen it, we've seen it happen, it's just those are the more challenging ones. So the 2-year, you had a question?
If you don't have a 2-year rule, just your country didn't care, US government didn't pay, is it possible to apply for green card?
Yes, so if the 2-year rule doesn't apply, your J1 is just like a variety of other generic visa. There's nothing about it that would be particularly problematic, other than that 2-year requirement. So it's important to think about, if you've got that 2-year residency requirement, that's the first consideration is, can this be waived? How would I get it waived? And then when do I get it waived? When you get it waived, unless it's something that an attorney tells you is going to take a really long time, like a very complex case, you can submit the waiver application with the H-1B or the L or the green card petition. There may be risk in doing that because you don't know if you're going to get both things approved, but that's a common strategy. Other people try to get the waiver first, just to see if they can get it. If the more complex and difficult the situation is, the more sense it would make to get a jump on that, getting the no objection letters, for example. Any other J1?
So there's no issue doing that early, trying to get the waiver?
Well, there can be, if it depends on what you need to do to get the waiver. Let me put it this way. So let's say we're talking to someone who's got government funding, they've got a potential hardship claim. Maybe when they came here they were single, now they're married, they've got a child, it's a completely different language and culture. Their spouse doesn't speak their native language. So for them to go back to the home country would represent a hardship. So there, we'd want to have enough time to prepare the materials to support it. Like you'd want affidavits, you'd want maybe studies of the relative quality of healthcare in the two countries or different things like that. And so those steps you'd want to know about and start taking in advance, so that when it's time to file the petition, you've got it all ready. If you need a no objection letter, you'd want to get that in advance. They don't expire, so there's no reason to wait necessarily. Yes?
In the J1, you can also work in the academia for some years.
Yes.
And if you see a job is already predicted before this, then how much time before you push to take care of the change visa category if there's no waiver for it?
How long does it take to change visa category?
How much further before your visa ends should
Oh.
you take care about new visa?
That's a good question. Okay, let's talk about that for a minute, unless there's any other question about the 2-year rule. So yeah, the question is, so when do you time that transition? So there's 2 very important rules that you would need to know. The first is that if you file to change status before your current status expires, so if you don't wait until after you've lost status, then you're eligible to change status, number 1. And number 2, during the wait, even if your underlying status expires, you're still able to stay here legally. You can't travel, you can't come back from travel abroad, but you can stay here safely while you have that pending application. For example, let's say your J1 ends when you get your degree. Let's say you're graduating in May. So your J1 status expires shortly after getting that degree. If you file to change status, let's say to an H-1B or something like that, before May, then you're able to stay until the decision is made on the H-1B. Even if it takes 6 months, you're not considered in violation of status. If you decide you want to go home, in the meantime, you can't do, you can leave, but you can't come back. You don't get a continued benefit to travel, but you're allowed to stay during that period. So that's one important aspect of the decision. Did you have a question?
To stay but not to work, obviously, right?
Yes, to stay but not to work. It's only permission to stay here.
But what if you have DS4 that has a longer, I don't know.
So if your underlying status is valid, it's sort of like there are 2 separate tracks. So this track of your J1 work authorization would continue while you're waiting for a decision on another application. What I'm talking about would look more like this, where your J1's about to end, you want to file that new petition sometime before that. And then you're allowed to stay while you're waiting, but you can't work until it's finally approved. So the other big consideration is how long is this next visa going to take? What's the situation? We'll talk about that as we go through the main work visas in more detail. Some visas can be approved in about 45 days, maybe 15, maybe 2, it depends. We've seen them approved as quickly as 2 days. Most visas can take months and months. So it really all depends. What would be nice from a security sort of comfort level standpoint is to file that change of status so that you have a seamless ability to work. So if you're filing for an O1, for example, which we'll talk about, it would be great to get your degree, walk off the stage, and walk into your job without, seamlessly.
Does it mean when you say that a visa may take several months for you to get, does that mean that you spend all that time without your passport also?
No, and so this is an interesting question because it raises an important distinction that most people find very confusing, and I think it's even immigration lawyers sometimes use the wrong terminology. So there's the visa, which is strictly a travel document. That's in the passport. The visa is only relevant for somebody who wants to enter the United States. They're outside the US. So that document's only issued by a consulate or embassy. You can't get one from within the United States. But we often use the term visa. I'm on an H-1B visa. I'm on a student visa. I'm on a J-1 visa. And that's where the confusion comes in, because if you're here in the United States, you have status. So what you're applying for is status, not a visa. Does that make sense? Because sometimes people think that they're the same thing.
Yeah, just ask that because I
Yeah.
think most of us have to go to conferences,
Yeah.
and so traveling outside the country is something that happens often for many of us.
It happens often, and so it's good to know that when what your attorney is applying for or your employer is applying for, when they file something within the United States, it's not a visa. So even if you get an approval, if you then travel outside the United States, you're not done. You have to go and get the visa and then come back. And sometimes that confusion, because often we use the word visa to mean two different things, can create problems. But no, there's no passport involved when you submit a petition to change status. You just provide the government the passport information, a photocopy, and that's it. You hold on to the passport. So while we're on that subject, maybe it would be helpful, and then we'll move into the visa categories, to talk about the travel issue. Have any of you experienced difficulty, delays in getting a visa? Some people do, some don't. So the visa system was set up, I don't know if any of you are aware of this, was set up after World War I. Before World War I, nobody really had passports. It just wasn't a thing. After World War I, we started being concerned about where everybody was from and making sure they were okay. And that's what the visa system was designed to do. So the visa represents that someone abroad working for the government has met you face to face and you check out. They believe you're entitled to present yourself to the port of entry at the airport or the border and come into the United States. So there's a lot that has to go on behind the scenes to issue a visa, and that's where a lot of these delays come in. The most common delays that we see when somebody goes abroad, they think they're just going to renew their F1 or their J1 or what have you. But let's say you go home to visit your family, you decide to get a new visa to be able to come back in. The consular official says, so what are you doing at Berkeley? What sort of things are you studying? Oh, I'm working on some certain esoteric technology. They may think that what you're working on is something that's protected technology by the US government, and that maybe you've got access to something that would be harmful. So there's a process they follow to check that out that can take weeks and weeks and weeks. And that leads to something called administrative processing. You've probably heard about that, or maybe some of you have experienced it. So that's one of the most common forms of administrative processing for people in your position is that type of technology check, because we have these rules that deal with the export of certain technology. So it's important to think about if you're working on any kind of sensitive area, the more it has to do with things that might be used as weapons or might involve defense or security, the more likely you'll have that type of delay. And, you know, attorneys can help to explain to the consulate ahead of time why you're not subject to those rules, to save that type of delay. There are also other types of background checks that have to do with maybe your name, unfortunately, matches a criminal, and then they have to make sure you're not the same person and all that good stuff. All right, let's, if there are no more questions, we can move on. So what, yes?
When you say that we have J1 2-year restriction, can we use the L1 to come here to do the business trip?
If you have a J1 2-year restriction? Yeah, so then the three visas, the three things you cannot get if you have that 2-year restriction are the L1, the H1, and a green card. Any other type of visa would be, you'd be able to come and go, but then once you wanted to go into HL or green card, you would have the restriction. So these are the general categories we'll talk about now of the types of work visas for entrepreneurs, investors, and also just generally anyone transitioning from campus to working for a private employer. The four main types of visas are the H, E, L, and O, like hello, so that's a little acronym to help remember. And then also the TN category, which is specific only for Canadian and Mexican persons. So we'll talk a little about all of those. In brief, here's kind of the overview. The H-1B is about what's called a specialty occupation. Again, the definition is from the 1950s. But it basically means any job that requires a specific degree. So an accountant requires typically an accounting degree. A lawyer has to have a JD. A doctor, you know, all those types of things. So when you get into the more esoteric and modern fields, there might be 4 or 5 different degrees. There may be no exact degree that quite fits, and so we have issues sometimes explaining to the government why it's a specialty occupation. The more esoteric things that involve usually applied mathematics and computer programming and those types of things. Then we have, we'll talk a lot more about the H-1B, but there's also a variety of H-1B we'll talk about that's subject to the cap and a type that's not subject to the cap. Someone mentioned earlier having cap exempt H-1B. You have that through Berkeley, I assume. Yeah, they have programs here for that type of H-1B, and we'll talk more about that shortly. Then we have, for certain countries, there are treaty-based visas called E1 and E2. And there's just a more or less random collection of countries that qualify for these. Some of the important countries that do not qualify for E1, E2, unfortunately, China is one, and Brazil is another. So those are important restrictions on some pretty significant countries. But a lot of other countries have that benefit. Those are treaty-based visas where you can start your own company, invest capital. If it's available to you, it's a pretty good, straightforward option. The L1 category is the intracompany transfer. This may not seem like an obvious choice, but there are plenty of people that turn to this. If you start a company outside the United States and work abroad for 1 year, and then come into the U.S. to work for a subsidiary or related entity, there's a visa to do that. This goes to what I said earlier about sometimes the best path to stay is to leave, because that L1 can sometimes be the best option. The O1 visa is for aliens of extraordinary ability in science, business, or arts. This category has been used more and more by people at the graduate and postdoc, that higher level of education, working in really cutting-edge fields. Maybe by the time you graduate, you've got your name on patents, you've got extensive citations and publications, you're refereeing journals and you have awards and things like that. So we actually use this visa category quite a bit for people that are starting up companies. We'll talk about that in 01. I did have a case that was approved in 2 days, which was pretty remarkable. It's not the norm at all. But the good thing about this 01 category is you'll see, it sounds very hard to reach. Most people don't think of themselves as a person of extraordinary ability, but the test is you only have to meet 3 categories out of about 8. That's less than 50%. It's a very strange test. It is designed to be limited, so it's certainly not open to everyone, but not quite as hard as it may look. And the TN, I have here Mexican citizens, obviously it's Canadian citizens as well, working for U.S. employers, so you cannot start your own company with a TN, but it is a specific option that's available.
Quick question.
Yes?
What's the difference between the O1 and the EB1?
Good question. So the O1, so all these alphabet soup, if it's a single letter, for the most part, like H, 1B, L1, E's, O1, those are all non-immigrant visas. They're temporary visas. And the EB, anything that starts with EB is a green card. Employment base is what the EB stands for. So the green card is the permanent status. Is everybody clear on the difference between non-immigrant and immigrant? Would anybody like me to explain that? Okay. So basically, EB is the green card parallel to the O1. So if you qualify for an O1, and we'll talk more about it in a second, but if you qualify for the O1, there's a very similar test for EB1. So you still have to apply, you still have to get approved, but you're basically taking your O1 application, repackaging it, and submitting it to get the EB1. And two of the categories we're going to talk about have that sort of parallel green card. I'll mention it as we go through. So the H-1B is the first of the main non-immigrant visas. This used to be what we thought of as the bread and butter, most normal path forward. But what's happened as technology has exploded, there's been more and more demand. We have a cap of 85,000 H-1Bs per fiscal year. The fiscal year starts on October 1. You can apply 6 months ahead of time, which works out to April 1st usually, sometimes March 30th. And there are usually about 2 to 3 times as many applications as there are available visas. So the government conducts a random lottery to determine which applications get selected. It's a very bizarre way to approach things, but it doesn't matter whether Microsoft filed or a startup company files, they all go into the lottery and everybody has an equal chance of their petition getting selected. But if your petition gets selected, you'll know that probably in May, but you still won't be able to start until October. Because that's when the fiscal year starts. So the lottery system is obviously the main challenge. It's why the H-1B is still a good option. It shouldn't be your only option because it may not work. It may not work the first time. We had one person who had several years of trying, and on their 3rd attempt, they finally got an H-1B. They got selected. Another issue is something called the prevailing wage. That isn't really much of a problem here in this part of the country. People are paid really well generally, so the government has these salary requirements for each metro area, for each position, and your employer has to show that they can pay that. This prevailing wage is more of an issue maybe for a startup. It may be more of an issue for a nonprofit or some entity, like smaller employers can have a hard time. The third challenge with the H-1B that I mentioned earlier is this specialty occupation. This very antiquated way of looking at what we would just say, basically, if it's a STEM occupation and you've got a STEM degree, that ought to qualify, but it's not that simple. The H-1B is issued initially for a 3-year period, and there's a 3-year extension normally available, so it'll last up to 6 years, which is a good, stable platform to seek a green card. So that's plenty of time to work on that. Questions about the H-1B before we move on? Yes?
It has to be sponsored by a company, right?
That's right, yeah, it's a good question, because the H-1B and all of these have to be sponsored by some other employer. You can't sponsor yourself. And that leads to a very important principle, which is a kink for a lot of startup companies that don't realize this. Let's say you found a company. You own and control that company. You can't file your own H-1B petition because you're basically considered a self-sponsor. And with the, one moment, but if you own less than 50% of the company, significantly less, let's say, you don't control it. So then you could actually have your company petition for you. It's kind of a little puzzle built in.
So, can I start my company with H1B? Can I incorporate the company?
Okay, so there's, you have the cap exempt H-1B. I did want to talk about that. So each H-1B is specific only for that employer. So if Microsoft, let's say, applied for your H-1B, that's who you can work for. You can transfer the H-1B to another employer, but that new employer has to file their own H-1B petition. So once you are counted against the lottery, once you win the lottery of H-1B, it doesn't matter who your starting employer was, because it's easy enough to transfer to any other employer. You're much more what we call portable. You can move around relatively freely. If you're on a cap exempt H-1B, such as the one that Berkeley provides, and some other universities provide as well, you cannot port to a cap subject employer. You can't bypass the lottery, in other words. You can only transfer to another cap exempt employer, which would be another nonprofit, like another university research institution. So it's a difficult transition. It's still possible. You get in line like everyone else for the lottery, and if you get selected, then you can work for that private employer.
But can I start my own company?
You can't do it without the H-1B in hand. So in other words, what you have now is an H-1B that allows you to work for Berkeley specifically. It does not allow any other employment, even your own company. Technically, that's a violation of
Only your
of
own
your
university.
status.
Right?
What's that?
If you start your own university.
Yes, you start your own university and your own accelerator. Yes, that's true. But does that make sense? So you can't, you're confined in a way within that context.
Fine, but is there any way that I can start a company as a postdoc with H1B?
So I would say not,
I'm not working for the company.
yes.
Let me put it this way. So I will still be staying with H1B until I resolve my status.
This is an interesting question, and I don't, again, so what I'm trying to give you is not legal advice, so please don't go out and do this, but think about it and then go talk to an attorney about your specific situation. You can technically do the following without violating your status. You can actually start a company. You can type up the name of the company, file the application with the appropriate authorities, and that's your company. You can't do anything with it, but you can start it.
So you can incorporate.
You can incorporate, and you cannot act as the owner, operator, CEO, director. You can't actually run it until you get the visa. So where that leads as we go through this sort of map is, if you have this entrepreneurial idea, you don't sit and wait and do nothing until you get your visa. You actually would go ahead and incorporate and take some very small baby steps, so to speak, towards getting it up and running, but you can't legitimately run it without the right visa. We had a situation where a grad student founded a robotics company, and it just took off. And before they knew it, they were in the press, and the press was saying the founder and CEO, and they had his picture and his name, and it was like, oh, this is too much. So you have to be careful. But yes, you don't have to necessarily wait for, you can't do nothing, but there's not a whole lot that you can do without without the work authorization.
So it sounds like if you found so I'm on an F1 and I'm actually doing an MBA here. So if I were to found a company and I had co-founders, so actually for the people I'm working with, who would all actually be significantly below that 50% sort of mark, we could use that company to sponsor each other. We're all...
Yes, you certainly could. And when we get to the E, you'll see there's a whole different path for you because you said the UK?
Yeah.
Yeah, so UK is one of the E1, E2 countries.
Okay.
So that creates a different scenario. So what we were just talking about with you is this H-1B path. So just H, E, L, and O are all sort of their own little universes of visas. In the H world, you cannot own the company because you cannot self-petition. So that is a good segue with your question to the E, because this is a totally different creature. And if it applies to you, it's a really much better path for someone who's entrepreneurial or wants to start their own company.
So that one doesn't work for China, Brazil?
It doesn't work for China or Brazil. It works for Korea, it works for UK, it works for a lot of other countries. So I will talk about this one. They're E1 and E2 are basically the same except for the way that you qualify. The way that you qualify is that your country has to have the right visa with the United States. There are trade agreements and there are investment agreements. Some countries like the UK have both. Often countries have both. But there's charts that show you which countries have which treaties and which ones apply. The difference is primarily if you're in E1, you're doing some existing trade between the US and some other, your home country. Doesn't really apply to most foreign students. The treaty investor is that you invest in a company here in the United States that you own and control. So control is important for the E. If the majority owners of the US company share the right nationality, so over 50% of the owners are UK persons, then that company would qualify for the E too. And then, so it's based on a substantial investment, which means it's not that you have to come up with $500,000 and invest it, but investment means funds, it means intellectual property, it means anything that can be valued, inventory, equipment, supplies, even agreements of different kinds. So you were going to ask a question about?
If the founders from different countries, which all fall under with the E1 or E2, it's okay.
So in order to have nationality, for the company has to have the nationality.
The company's in the US, but the founders are from different countries.
Right. So let's say that you have 3 founders. One's from the UK, one's from Korea, one's from Switzerland. All 3 of those qualify for these visas. If each of them owns less than 50%, they each own a third, there's no E2 for anybody because the country doesn't have any nationalities. If you only have 2 investors and each owns 50%, let's say a UK and Korean person, then the company has UK nationality for the UK person and Korean nationality for the Korean because it's 50-50. Each of them can control the company through veto power. So you have to first establish that the company in the US has the right nationality, 50% or more ownership, and that is the first key to getting this particular type of visa. You have to invest. Well, I mentioned earlier, investment includes the goods, the equipment, the cash, personal debt. It includes intellectual property if there's some patent that you've got that you're going to use and develop through the company. All right, so here are the kind of the highlights of this visa type. Both of them are processed directly by the consulate. So all these other ones are processed by the Immigration Service, who is really it's a classic bureaucracy. And the consulates and embassies tend to be higher quality. They tend to be better at understanding business, about promoting business, and about supporting these visa types. So that's good. Generally speaking, you get a 5-year visa in most cases. Some countries are different, but for the most part, it's a 5-year visa. You have to be at or near the start of actual operations. So to the earlier question, yours about before you get the E2, you would have to found the company and start getting a lease and get it up and ready to operate. But you can't operate it until you get the E2. The E2 applies not only to the majority owner, but to people with the same nationality who are either going to be supervisors, executives, or have essential skills. So let's go back to the UK example for a moment. So let's say it's not your company, but you find there's someone else who's from the UK who's got an E2 company. You've never worked for them before, you've never met them before, but they've got the same nationality as you and they want to hire you for some essential skills. They would need somebody with an MBA to help them with their company. They could hire using, through their E2, could hire you because of British nationality. So it's quite flexible in that sense. And I would say this is probably the second most common strategy that we see if the person's from a country that qualifies, because it's just so much more, it's the closest thing we have, I guess, to an entrepreneur visa. Yes.
You said recently that if you have O1 visa, it's like very similar to E1, EB1
Right.
when you apply for green card. What's the analog for green card process if you have E1, E2?
There's nothing at all. So there's not, that's the catch here. Let me see if I've got a slide on that. There's not any parallel green card path like there is with the L1 and with the O1 and EB1. So you can't just take the E1, E2 application and convert it into a green card. There are situations where at the planning stage you can aim towards certain green cards in the future, but it's not necessarily designed that way. On the other hand, the E2 is indefinitely renewable. It's 5-year visa, but you can keep renewing the visa. And we have people that seriously have been on E2s now for 30 years. They just keep renewing it. They don't want to have green cards because they like the freedom of traveling back and forth, or maybe they just don't want the tax obligations or what have you. So it's a very, very flexible visa in that regard.
But again, you renew it at your home embassy.
You have to, so you have to go back to the embassy. And so there's something interesting too. Once you have an E2, you get registered at most consulates. So the first time you apply, you have a big notebook of material to prove your eligibility, and you give that to the consular official. You actually usually deliver it, you don't hand it to them. But they review it and go through a long process. Once they've approved the E2, they register the company so that the next person who wants an E2 from that same entity, it's a much simpler process. There's no notebook. They've already been approved. The company's been approved. So it makes it more streamlined. Yes?
Going back to that question, sorry for cutting before. So if I incorporate a company, then I'm not CEO or any of these Cs or any roles, but can I be a founder?
Yes, you can be a founder. Thank you. That's a good question. You can be a founder of a company without the need to have a visa. You can't do anything for the company. So it's a very, and I'm not, you know what I mean? It's a difficult, like a little bump in the road. You don't want to go too fast and miss what I'm saying. You cannot operate the company.
Okay.
You can't work, but you can create a company, which makes you a founder.
Yes.
You can own a stake in a company. So it's an interesting, as a almost universal rule in this country, you can own whatever you want. Nobody will stop you from owning stock. You could own 100% of the stock of a company. You just can't run the company.
You just have to trust your manager.
You got to trust your team until you get the right visa. So we often see the founder takes a back seat for a little while and holds on while they work on getting their work visa.
For certain visas like J1, you cannot get money out of that because it only allows you to...
That's right. Well, you could get a return of capital. So there's what we call active and passive investment, and this is really an important concept for a lot of you, I would think, if you're considering starting your own company or doing these types of things. So an active investment, generally speaking, is one where you invest money and you're working. So if I invest in a restaurant, I'm going to run that restaurant. Maybe I'm not the day-to-day manager, but I'm going to be checking in and seeing how they're doing and making decisions, basically running the company. That's an active investment. A passive investment might be, I bought a building across town and I'm just sitting on it. Maybe I have tenants in it, or maybe I bought a piece of art and it's just sitting on a wall. I'm not doing anything with it except protecting it. That's considered passive. Passive investments don't require a visa. You can't even get a visa for a passive investment. It's active investments that require the visa, and the line is hard to see, and a lawyer can help you see it in your particular case. That's kind of what we spend most of our time doing, is helping people see where the distinction is for them. But that's where we try to keep the dividing line, is we try to, listen, keep it passive. You can put money into this company, found the company, but you got to stay away from it. You can't run it. And if the more that's a problem for some people, they just can't, by their nature, cannot help not running the company, like the person that ended up in the newspaper, you want to try to maybe do something else. Maybe that's not the strategy for you.
How about J1? Is the same?
J1 is exactly the same, because the visa type that you get restricts the activity you can do. Anything outside of that could create a risk of a visa violation or immigration violation. That can have really bad consequences if you get caught. And it's important to really try to stay within the box and know how to get to the next place. Like your questions are all really good, and they're the type that we deal with all the time. And, okay, how do I make this transition specifically? That's something that you'd really want to sit down with somebody and hammer that out, because that's where the combination of your idea, your plan, and the knowledge of somebody like me would come in and meet, is like, well, let's figure this out. Let's work together and figure it out.
How
Yes.
often do they get caught? Somebody on J1?
How do people get caught? Okay, yeah, so there's more ways than there used to be. I'll tell you some anecdotes that are true. These are all real examples. So somebody comes into the United States, and the officer says, got a cell phone? Yeah, I got an iPhone. Can I see it? Sure, you can see my phone. They start scrolling through the phone. They see emails from that person to the company that they said they weren't working for. They see that their email address has a suffix that's a corporate entity. They're not going to school. So they catch people by looking at their LinkedIn profile. What's your name? Let's look you up on Google. Oh, look at that. It says you're the CEO of a U.S. company. That's interesting. I thought you said you were on a J1. So they use the internet as their main weapon nowadays. They look at things like your business card. So if you have a business card that holds yourself out as the CEO of a company, that would be a big problem. If you hold yourself, if you hold yourself out as founder, maybe not quite so big. So they look at all those things as indicators of a potential status violation. That's probably the most common tool, yes?
But are you required to give those things? When they ask you, can I see your phone, can you just say?
No, you're not.
But also, who are they and where do they find?
They are the customs officials. So the customs officials are the combined just sort of law enforcement when you come into the country. So when you come off the airplane and you go through the inspection process, that's a customs officer. You get off a boat or come in through land, it's the same thing. So they have the right to not only look for immigration violations, they look for criminal violations, they look for customs, goods moving into the country that aren't legal. So it'd be very intimidating. And what happened in the case, a couple of real examples, was the person innocently showed the government their phone. They're like, oh yeah, let me show you, here's the email. And so the officer has the phone in their hand and it's unlocked, and they just start looking through it and
It's
find what they
in the
want.
airport, or where else?
It's the airport. Terrible idea. Never hand the government your phone. Sometimes they can compel you, and that's a whole different topic, but you shouldn't be dumb about it. You know, if you're going, be careful, your online presence is very easy to search, and if it conflicts with your immigration status, that will be found out. The other way that's more and more common, I'd say these days, is they just can tell because they've seen it before. They just sort of, these officers do nothing all day long but watch people coming into the country, and they know what people look like. They sort of get a sense of what people look like when they're not being truthful. They go, really? I mean, you're here for a conference, huh? Come in here, let's talk about that a minute. And so they have their ways, as they say. But most people that get caught on the bad side of these immigration situations, it was the LinkedIn profile, the company website, or something like that. They were easy to find.
So as long as if you have an American citizen co-founder, as long as you limit your title to co-founder on anything on the interweb or whatever, and even if you apply for money, as long as they're sort of the name on it, that's still fine. Or it's fine for the business to be going if they're driving it.
This would be in the category, this is not legal advice, so don't run out and do this. But generally speaking, that is accurate. That if you are careful to describe yourself in a way that doesn't imply you work for the company, if you don't, and you put money into it, you're a co-founder, but there's obviously someone else who's running the operations, that's an okay scenario. That's a realistic scenario. There are plenty of people that, I know a person from Canada who's a co-founder. He put in most of the money, but he doesn't want to operate the company. He just wanted to fund it. He wanted someone else to run the company. So those scenarios really do happen, and it's not an immigration violation to just have founded something. Did you have a question? No? Okay. Anybody else have a question about this?
So when you start the E1B process, and there are two parts. First, for what's 484.
Oh, the two parts of the green card? Yeah, so maybe we can switch gears to talk about the green card just a second. So now we're switching all the way over to not the temporary visas, but this is the permanent resident process. We're just going to jump there for a minute. So that process, we mentioned EB earlier for the term employment-based. There are three main tracks to getting a green card. One is family-based, which not surprisingly is FB. Then there's employment-based, which is EB. And then there's something called the diversity visa, the lottery. I don't know if you've heard of that, but this is a lottery that we conduct, and you can still do it. It's still legitimate. It's the craziest thing, but you can submit your name and try to get selected to get a green card at random. There's 55,000 of these per year, and each part of the world gets a certain allotment. So the more people in your part of the world, the lower your chances, but you know, it's out there. But for the employment-based categories, they generally start with what's called an I-140, which is an immigrant visa petition. So that's the first step. That's normally the employer's petition. And then once that's been approved, the employer says, I would like this person to have a green card. Then you have your own personal application, which is the I-485. And that's all about you. It's, you know, you're not a criminal, you have no immigration violations, you've always done the right thing, you don't belong to any terrorist organizations or anything like that, and you have no communicable disease. A lot of these requirements go back to the 1800s, so they're still there in the law.
How about, so when I get approved for the first part, can I then start working with the company, or I need to wait the whole process?
So that whole process, the I-140 and the I-485, none of that gives work authorization until the very, very, very end. So, but there's a catch. So, in other words, the I-140 doesn't let you work. The I-485, you can't automatically work while it's pending. But when you file the I-485, there's a work authorization application that can go with that. And that, once that's approved, then you can work. So sometime during the green card process, if the green card process is as long as both of these front rows of tables, then somewhere around the middle, you can start working even before you get the green card. So, all right, so back to the E1, E2. So the main thing that you have to have, because this goes back to our passive versus active investment idea, you actually have to get sufficient physical premises set up. You've got to actually get a business founded. You've got to get a lease. Getting a lease is not an active investment. It's just passive. You have to enter into that engagement. And then you have to create a business plan, usually a 5-year business plan. And this should be the same quality that you would present to a bank or to a group of angel investors if you were seeking financing. The L1 is another option. This is, of the 4, this is the least commonly used, but it's still a very good one for some to keep in mind. The L1 is for intracompany transferees. It has 2 flavors. L1A is for the executives and the managers. This would typically include the founder of a company. The L1B is for employees that have specialized knowledge, and that's pretty similar to the specialty occupation for the H1B. It's another very, very old term. Both types require 1 year of employment abroad for a company which is related to the U.S. company. So let's say, going back to this E2 example, just to use it as your scenario, we'll pretend that somehow the E2 doesn't work. You've got 3 founders, each of you own a third, there's no distinct nationality, so the E2 doesn't work for anybody. One potential option would be to found a company outside the United States. Everybody works for 1 year outside the U.S. Then when you create the U.S. entity, you transfer to the U.S. after 1 year abroad with the L1. So sometimes that's how this starts. Another way this would start is if you really have no obvious clean path and you're ready to get your company going. So let's say you apply for the H1B, you don't get selected. But you've got a great idea and time is of the essence, and it's more important to get that company off the ground than necessarily to have it right here. People go outside the U.S. and start the company and then come in with visitor visas to maybe market. You can't run a U.S. company. You can sort of market your foreign company to U.S. customers and sort of lay the groundwork for eventually coming back to the U.S. with your subsidiary or related entity. We have plenty of clients that do this type of thing nowadays. The employer abroad and the employer in the U.S. have to be related, and as you probably know, MBA probably knows better than most of us, but there are different types of qualifying relationships. They can be commonly owned affiliates. One can be the parent, or one can be a branch office of the other.
Yeah, does the company have to be founded outside of the U.S. or?
It doesn't have to be. So you could found the company here, and then you realize it's not going to work. And you realize, okay, let's create a related entity abroad. The attorney can help figure out from a tax perspective, is it better for that new company to be a subsidiary? Is it better for it to be the parent of the U.S. company? They can help sort out all those details. But it doesn't matter which one was founded first, and it doesn't matter which one is the parent. In fact, in some cases, more and more frequently, we see what's called a flip, a corporate flip, where the U.S. company starts out as the subsidiary, and then it becomes the parent. So it just literally swaps places with the other one. So yeah, it's not that relevant. Yes?
So I have a good friend who's an executive at a tech company that's well-funded. He's got 200 people there. He's mentioned that the L1 has become an alternative
Yes.
to the H1B.
Yes.
And that's growing in popularity. I've also heard anecdotally that there's been some clampdown on that as well.
That's true.
Could you speak to that? It sounds like you have a good sense.
Yeah, so that has a lot to do with 2 different scenarios. Let me see if I've got a slide on it. I don't, so let me just talk about it here. So there's two different issues that attack the L1. So let me tell you about those because it's good to kind of know about these. One is there's a perception that the L1 has been abused to facilitate what we call offshore staffing companies. So maybe a company based in India, for example, some of them happen to be, so they tend to be the targets. The government thinks instead of doing business for the company doing its own business, like a software developer would, that the staffing companies are sending people to work at different companies to replace American workers. That's what the government thinks is happening. So if the business model that you're using for the L1 involves sending the workers to some other employer's work site, and there are many, many, many reasons to do that. Most of them are legitimate. You have to be careful that the government knows that it's a legitimate reason and that you're not one of those staffing type companies. So an example might be you provide specialty consulting in a very peculiar area, a very unique cutting edge area. So you might have to send your team out to GM and Toyota and different automobile manufacturers because they don't have that expertise in-house. That's perfectly fine. What's not allowed and what the government has really been cracking down on is you're just sending workers to replace at a lower cost the workers that they might have had. The second issue that's really been attacking the L1 is this, I guess I would call it, it's not a change in the actual rules, it's a change in the perception of those rules by a government that gets more and more meticulous. So it used to be if you said this specialized knowledge category, let's just say, well, I have specialized knowledge. I helped found our company and we have a proprietary software. So obviously I've got specialized knowledge of our own proprietary software. For about 25 years, that was perfectly fine. That's all you needed to show. Now they'll make you prove that your knowledge is different from other people in your own company and people in general that know about software. Why can't somebody just pick this up after reading a manual? So it's become harder in that sense. But you're right, and your friend is right, it is becoming more and more of a strategy strategically used not just by existing foreign companies that create operations here, like say Samsung, but by companies that start out here and they can't get a visa to work any other way. One of the main challenges with the L1 is what we call the 1-year new office limitation. So if this scenario that we're describing where you start the company here, you move away and try to come back, if you've been doing business in the US for less than 1 year, then you get a 1-year L1 to start with. It's pretty easy to get. But then to get it extended, you have to prove that your company is doing well enough so it's not just you, that you've got other people supporting your operation. For a single person startup, that can be a significant hurdle. So it's good to talk that through, figure out what your plan is. It's easy to get the 1 year, but now what's next? You want to think about that before you start. Yes?
For a single or two people startup company, what's the best visa option? Like if you want to hire a postdoc or a grad student from Berkeley, what's the best way to go forward to hire them?
There's so many factors that go into that it's hard to say. I would say there's really not a best way that works for everyone. There's definitely a best way that works for each of you. And so I would say that's really where this comes together. So try to give as much detail as I can without saying, here's what you should do. But the scenario, again, is two equal owners is what you're basically talking about. So there's a lot of factors that would go into that, but if those two individuals came to see me, we would start looking at what countries are you from? Is the E1 or E2 available? Tell me more about your business model. Is this something that absolutely must be here, or does it work to start and then move? Maybe one person qualifies for E2 and the other doesn't, so you'd end up each having a different option. So there's a lot of creativity that goes into this somewhat like, I think, probably not many attorneys would use this analogy, but sort of like an artist looks at a set of paints, and one person can take those paints and make a masterpiece, the other, I don't know what to do with them. But you don't just pick a color and say, here, you'll be blue, Yes?
So if you have like two companies, in one in US and the other in the other country, so you have to work 1 year in the outside.
Yes, at any time you spend in the US, that's the next slide here, I believe. No, it's not, but it should be. If any time you spend in the US does not count towards your 1 year. All right, so let's say you you move outside the US on January 1st. So you'll meet the 1 year on December 31st. That's 1 full year. But if you come into the United States for 30 days, now you need another month to meet the 1 year. Does that make sense? So yeah, so if you found the company overseas and go there to work, but you plan to be here once a month for business, that's okay, but it just takes you a little bit longer to meet your 1 year.
And the company that you have to work on overseas should be related to the one founded here?
Has to be, yes. Has to be related as its parent, its subsidiary, its commonly owned affiliate, or a branch office. There's all sorts of ways, but it really has to be essentially the same company.
And how well should the company overseas be doing, like financially? Should it be?
So it should continue to do business. That's a good question. You cannot just fold up the business overseas and relocate it here. You'd have to truly maintain that international operation to some capacity. So for a software development company, just as one example, you might keep certain programmers abroad and move the marketing team to the United States, for example. All right. So you were asking about the problem. Here's where we talk about some of the issues. One is that the specialized knowledge question is carefully scrutinized. There is a parallel path for the L1A. So for the executive, the manager, the CEO level person, there's a green card path that's exactly identical to the L1A, so that's a very smooth transition that you often see. If your company is large enough that you have 10 L1 approvals, so your friend's company with hundreds of employees, you get something called a blanket petition. And what that means is instead of going through the immigration service, you just bypass them completely and go directly to the consulate. So it turns the L1 into something that resembles the E1, E2 that we talked about earlier. So for people from China and Brazil that don't have access to the E1, E2, this becomes a very, very flexible and powerful visa type. The other good thing too is a spouse can obtain work authorization. So most of these other visa types, spouse cannot, but with the E and the L1, they can, which is nice. All right, and the last one to talk about for this evening is the O1. This is the extraordinary ability visa. It applies to extraordinary ability not just in science, but also business, education, athletics, and the arts. There's a lot of broad qualification here. We're doing multiple of these right now. We're doing one for a chef from Mexico, among many others. Robotics, just all sorts of interesting things. But you have to have evidence of ability in only 3 out of, it's really 10 categories. I said 8 earlier, but it's 10 total ways you could qualify. Now, even though you only have to meet at least 3, that doesn't mean if you meet 3, you're automatically in. You have to still show that you're considered a person of extraordinary ability in your field. And that's shown by things like your work is not just cited by others, they're actually discussing your work and expanding upon your work in a meaningful way. Maybe you've been involved in patents that have a far-reaching application. Maybe you've refereed articles in prestigious journals and things like that. Here are the odds of O1s, some of you being O1 material significantly higher because at the level that you're at. So this is one we see more and more. It does also have a parallel green card, as we mentioned earlier, the EB-1. So depending on eligibility, it can make sense. What's happened recently with this category, though, is that, like everything else, if there aren't enough H-1Bs to go around, there's pressure in every other visa category. So the Immigration Service gets sort of a fatigue. Like what used to impress them, the bar just keeps going up. So a case that might have been approvable 10 years ago might have a harder time today. They might want more and more. I would say if all of your recognition is at the collegiate level, it can be more difficult nowadays. It's still possible, it's just become more and more challenging. And generally, the O1 is something that the government seems to be pushing out to somewhere slightly beyond, certainly beyond the master's degree, out of reach of that level, unless they're just really, really extraordinary things that you've done.
Is it something that the individuals have to file for an O1, or can a startup file for an O1 for a potential employer?
So the O1, and this is an interesting distinction, the parallel green card category, you can self-petition, but not the O1 itself. So you can have an O1 through an agent, which is sort of the workaround. So let me talk about that for a minute. That's a little bit confusing. So normally by default, the O1 has to have a petitioning employer, has to be a U.S. employer. There's an exception because this applies to the arts. You can also have an agent apply. The way the government wrote the rule is an agent can do any of these. It doesn't have to be just arts. It could be an agent for science. Well, what does that mean? It essentially can be used to almost self-petition. It's pretty close to self-petitioning. But often what happens is you'll have a foreign founder that wants an O1. They may just not take a controlling stake in the company, maybe stay just under 50% so that they can qualify for the company to file for them. And that becomes a more straightforward approach. Yes?
Would you, is it better to, can you use O1 alone with your lawyer, or would you advise somebody to always get to a lawyer and really get this done correctly?
Definitely would advise on a lawyer, and I'm not just saying that because I happen to be a lawyer, because I've seen what happens when people don't have lawyers. It's one of those things, like all of your areas, you could explain it to me for several hours and I would think I had a good sense of it, but I wouldn't do it right. I mean, it's just that everything's more complicated than it appears. And so the expertise that everybody in this room has, that's all similar in the sense that it doesn't seem like it would be that complicated, but it is. And so the simple form, anybody here can read it and understand what the form says, but there are issues about the way the government processes it, the way they view the evidence, that would be important to know that aren't there on the form. So I would say you definitely want to have, at a minimum, have the company hire immigration counsel. But yeah, there definitely ought to be some consideration of, hey, are we doing this right? Does this look like a good approach? I've had some cases where people come to me and they've already done most of the work. They've read the regulations, they've got everything organized. They present what's pretty much an almost complete application, and we're just tweaking and refining. And other people don't know where to start, or they don't even think they have a case sometimes.
Long before J1 terminates.
Okay, yeah, you asked that earlier, right? So the O1 is one where you have this option called premium processing. You pay an extra $1,400 something fee, and the government expedites the processing to 15 days. Sometimes the 15 days is they ask you to send more evidence. So that stretches it out to about 45 days. But it's still a pretty quick visa. It can take, depending on the complexities of the case and what you need to do, it can sometimes take 1 or 2 months to put the petition together, to get everything done correctly. So you probably want to just, based on that, think, well, if my J1 expires in June, and this thing might take, what, 3-5 months, you just want to start it in enough time so that when it does get approved, you would want to have it in your hands when you are finished with your J1. Other visa types take longer, like the H-1B. You need a much longer lead time because you have to file it on April 1st. If it becomes effective, it wouldn't be until October 1st. So it's more of a consideration of how long that particular visa takes.
Will we talk a little bit more about green cards? For example, imagine you applied for the green card through the national interest waiver.
Right.
And then you wrote, like, you're going to do your work to improve the American economy or something like that. And then you decided to switch to business and start your company. So will that be a problem for the, like, I don't know, for...
Yeah, let's talk about that in just a second. You had a question right behind, right? I wanted to
Yeah,
get...
just about the H-1B, because, I mean, they used to be able to expedite that as well, right?
Yes.
But that hasn't happened in, like, years, and it's probably not going to happen again.
Well, so the expedite fee was taken away for the H-1B in most cases, with a few, very, very few exceptions. One of the exceptions is the cap exempt age, the one that you're talking about.
They can still be expedited.
They can still be expedited. And extensions that don't involve any sort of change can be expedited. But yeah, you can't expedite it anymore. I hope that policy eventually does change. It's a symptom of the lottery. That's why it's happening. But hopefully that comes back. So yeah, let's talk about the green card a little bit, because we mentioned already there are different categories. The national interest waiver is a very important one to think about because it's almost like a slightly lower level than extraordinary ability. It uses the term exceptional ability, and which is silly. It sounds like the same thing, but if extraordinary is up here, exceptional is probably about here. So it's a slightly lower bar in terms of your accomplishments, which makes it a much better fit for someone who hasn't been out in the real world working. You're still at the academic level. You have those accomplishments. But your work has some sort of national importance. I mean, I can't imagine there's anybody here that doesn't apply to. So if you can make that argument, there's a green card path available called the national interest waiver. And with all of these green card categories, there's another very important rule that is worth thinking about. And it's this, it's a portability rule. So I mentioned at the beginning, immigration's like a pendulum. And every so often it swings really far in the other direction from where it is now. And the last time that happened was around 1998. And we had all these great immigration rules. One that often they're called AC-21. That's usually the way people refer to it. But those all came about during that period. And one of the rules that came out of that period of time says, if you have a green card application and the I-140 has been approved, so the I-140 is that first step, and your I-485, which is the second step, has been pending for at least 6 months, you don't have to work in the job that you got approved for. You can work in another job for a different employer, for your own company. You can do whatever you want as long as it's the same or similar occupation. And the reason for that rule was because the government was taking so long to approve things that people's interests in employment were shifting. So for example, if you have a national interest waiver I-140 that said you would work with this employer in this particular type of field, and now you want to work for your own company in the same field, that's allowed under this rule if the green card takes too long and you fall within that AC-21. So there's more portability for somebody in the green card process than there used to be, which is a very good thing. And it can really help so that you're not necessarily stuck if you made a decision and your green card employer is not the one that you wanted to stay with. for your whole career, you don't necessarily have to do that.
Sorry for switching up topics a little bit in terms of incorporation. So, suppose an F1 visa holder would like to start a company and would love to strategically doing their operational in the foreign countries. One day before they start a company, they secure a funding from angel investors. The angel investors would like to fund the startups given the conditions that they incorporate the startup in the US.
Right.
So, based upon these conditions, what's the best, accommodations?
I'm smiling because that's actually a case we have right now with a student out of Carnegie Mellon. And that was their situation. They're a founder of a very successful, exciting company that they founded with their F1. And the funders said, a condition of funding the company is A, you have to have valid employment status, which she did, and show us that you can continue to have status after your F1. What's next? So for that person, the question became even more important. It's not just, so when I mentioned at the beginning, think about your short-term and your long-term option. What she and I have been discussing is, all right, how do we navigate this? Because right now you've got 3 years of F1 status, of F1 work authorization. What's the next move? Things like the national interest waiver, things like this EB1 category. And then even things like, do we need to use the L1? Do we need to create a subsidiary so that you can run the company from outside until you can get back? There's a lot of considerations that go into that decision, but what you're talking about is very, very familiar, and it's more common to have those types of pressures. So now you've got yourself with a great idea, and on one hand you've got all these immigration rules creating pressure from one direction, and if it's a great idea and you've got investors lining up, pressure coming from another direction, and there's got to be where people like me and my colleagues can come in is to help navigate that and create a path. So that's really what we do, despite what you see on TV, I suppose, about lawyers. That's really what we're trying to do, is take the knowledge we've got and figure out a way to make everything line up. Yes?
It's right that for EB1, you have to first apply for the O visa, and then within the O visa you go for EB1, for the green card, or is it?
You don't have to do that. There's no requirement to do that. That's practically what often is the best situation. There are situations where for some people, and it's risky, so again, don't try this based on me saying this, but there are situations where you can go directly to the green card. That might be the more practical option. This situation you were describing with the pressure from the startup investors, sometimes that's the best path.
Guys, I'll leave room for one last question. Brian has been very, very patient, and we can, yeah.
All right.
One last question. This is good. This is good. Hey, a big round of applause for Grant. He's flown all the way from Austin, Texas, for you guys. Very, very helpful. We are trying to have them come over twice a year. But then I think, this is educational, informational, but I think for your specific cases, it's good to work with a lawyer for sure. Very, very qualified. They've been very, very patient, willing to work with you guys. So, hang around for some more time. Thank you again, Brian, for coming down here.
Sure.
I appreciate everything.